What is up, guys? It's me, Muddy McFly, your Swedish Attorney General, bringing you breaking news from the Virginia courthouse in relation to Yarid v. Ocwen. I haven't read this document fully yet, guys, so I'm going to be reading it along with you. So let's delve into it. I'm going to try and be a bit more precise with things today because I've got some more time on my hands. But this, I think, is going to shock everyone from the quick bit I did look at. So this is the bank responding to George's previous filing that was his response to stop the bank dismissing his claim. Now, there was a fundamental thing that George had to do in that response, and that was he had to show law as to why they shouldn't dismiss his case. He had to advance arguments that would prevent them from dismissing his case, and he had to essentially show that the bank were incorrect for applying to dismiss his case. Something George didn't do in any of that document. He failed to advance any form of cognizable argument in that document, and this is the telltale sign that he's done that, and we'll go through it now. Defendants Ocwen Loan Servicing and the Bank of New York Mellon, formerly known as the Bank of New York, a successor in interest to JP Morgan Chase Bank. So this just introduces who they are. Hereby submit by counsel their reply memorandum in support of their motion to dismiss the complaint filed against them by plaintiff George A. Yarid. Introduction. The plaintiff's motion to deny the defendant's request to dismiss case, docket number 20, plaintiff's opposition, to Ocwen and Bank of New York's previously filed motion to dismiss, a memorandum in support of the motion to dismiss the complaint, docket numbers 4 to 5, fails to rebut any of the legal arguments raised, requiring dismissal of the complaint. For example, the plaintiff still offers no basis which would allow this court to conclude that he, and not his Chapter 7 bankruptcy trustee, has standing to bring the claims he seeks to raise in the complaint. Now, this is an important thing, because George has given the bank this information. This is how stupid he is in that latest filing. He has provided the bank with information to allow them to now say this and advance even more arguments as to why it should be dismissed. The plaintiff's untimely request for a loan modification likewise fails to bring his complaint within the realm of a viable claim because he has no legal right to receive one after the foreclosure sale is completed, particularly considering that he has already defaulted on 2 loan modifications previously. He's an idiot because the bank hadn't brought that up. George brought it up himself in his own filings. Because the plaintiff has not alleged any facts or legal arguments indicating that he has a plausible claim against any of the defendants or any standing to bring claims related to his ongoing mortgage loan default, the entire complaint should be dismissed as to all parties. Jesus. Argument. Plaintiff's complaint should be dismissed because he has not rebutted Bank of New York and Ocwen's argument that he lacks standing to raise claims that belong to his bankruptcy estate. As explained more fully in the motion to dismiss, the claims set forth in the plaintiff's complaint are either expressly alleged to have arisen before the plaintiff filed for Chapter 7 bankruptcy in October 13, 2016, or undated, so that it cannot be determined whether or not the plaintiff would have standing to bring them. Ocwen and Bank of New York contend that dismissal is warranted because the plaintiff has failed to allege standing to bring the claims and because at least some of them clearly belong to the plaintiff's bankruptcy estate and can thus only be raised by the bankruptcy trustee. So what they're saying here is some of George's claims, when he went bankrupt, his trustee takes responsibility for everything. And if his trustee thinks that the house is an asset and the bank have acted incorrectly, the trustee is allowed to bring a claim against the bank to do it, to sell the house, to raise funds, to pay off George's creditors. That isn't what's happened. The bankruptcy trustee obviously knew that there was no claim here, so he hasn't brought any claim. George has failed to show why he has standing legally to bring that claim. Something that the bank made clear in all of their filings, show us, show us, show us, and he's failed to do it as usual. The motion to dismiss should be granted. Plaintiff offers nothing to rebut this argument. To the contrary, the new facts alleged in the plaintiff's opposition only further confirm that the plaintiff lacks standing and that amendment would be futile. Specifically, plaintiff's opposition now acknowledges that he fell behind on his mortgage in January 2009, but obtained a loan modification in October 2015. After making 4 consecutive payments under the modification, the plaintiff fell behind again in or around March 2016. So get that right, guys. George made 4 mortgage payments in 2015. That's all he made. 4 mortgage payments out of 12. 4 out of 12 payments is all he made. Plaintiff now suggests that his default was caused in part by lender-placed hazard insurance increasing the monthly payment amount. Yet, even if these new allegations are assumed to be true, these events still occurred well before he filed for bankruptcy on October the 13th, 2016. Further, the plaintiff has alleged no wrongdoing related to lender-placed hazard insurance because this was permitted under the terms of his deed of trust. See motion to dismiss, Exhibit B35. Ultimately, even after Ocwen and Bank of New York pointed it out in their motion to dismiss, the plaintiff has still not, and probably cannot, allege any claims that he would have legal standing to raise. Accordingly, the plaintiff lacks standing to bring the claims asserted in the complaint because they belong exclusively to his bankruptcy estate and should be dismissed. The complaint should be dismissed because the plaintiff has not meaningfully opposed any other arguments raised in the motion to dismiss. In addition to averring that plaintiff lacks standing, Ocwen and Bank of New York's motion to dismiss explain that the complaint could also be dismissed for a myriad of other reasons, none of which have been addressed in the plaintiff's opposition or successfully rebutted. Yet again, all George did with his last filing was give the bank information that he hadn't given them before, admit things that he shouldn't have admitted, and essentially just regurgitate the same old argument he has that the bank's mean to him and therefore the bank should let him stay in a house that he doesn't pay for, and that it's in the bank's interest to give him a ridiculous new modification of his mortgage to let him stay there after he's only made 4 payments in the last 2 years. You have to remember, guys, George is paying no mortgage at this moment in time. He's paying no money at this moment in time. 2016, he fell behind on the mortgage again. And 2015, he made 4 payments. What right do you have? You have no right. For instance, the plaintiff's claim for declaratory relief in count 1 should be dismissed because allegations that a lender has not demonstrated its authority to foreclose do not constitute a viable cause of action in Virginia, nor is declaratory relief appropriate where a foreclosure sale has already been held. The plaintiff does not rebut this argument. As another example, plaintiff's claim under the Fair Debt Collection Practices Act in count 2, reiterated in plaintiff's opposition in a conclusory fashion, still fails because he has not even suggested that Ocwen and Bank of New York would meet the definition of debt collectors subject to the Fair Debt Collection Practices Act requirements. Because the plaintiff does not offer any arguments which cure the defects in the complaint, nor does he even suggest that amendment could cure those defects, it should be dismissed with prejudice, pursuant to Federal Rule Civil Procedure 12, paragraph B.6. The plaintiff has no right to receive a third loan modification after defaulting on the first 2 and after a foreclosure sale has already been completed. An untimely request for a third loan modification, which constitutes the bulk of the plaintiff's opposition, does not allow plaintiff to escape his agreed-upon contract obligations under the deed of trust. As the Fourth Circuit recently confirmed, there is no freestanding common law duty in Virginia to grant loan modifications. And this is the bank doing what you're supposed to do, and this is what George was supposed to do, is find the argument, find the response, and find the case law or the specific federal statutes or something like that that back up what he's saying, which would have then advanced an argument that, you know, possibly would have gone to a jury trial or at least would have had some hearings over this. He failed to do that. Recognising that there is no contractual obligation for a servicer to offer a homeowner modification. So essentially, there is no obligations for banks to offer loan modifications. As such, wanting a modification is not a valid legal argument in opposition of the motion to dismiss and should be disregarded by the court. Further, although he did not disclose their existence initially, The facts before the court reflect that the plaintiff has already received at least 2 loan modifications in 2008 and 2015 and still could not afford this loan. The 2015 loan modification was particularly beneficial to the plaintiff in that it deferred $159,673.58 in principal balance, did not require any interest to be paid on this deferred principal, and would have completely forgiven this large sum in 3 years if the plaintiff had made timely payments. This 2015 modification also reduced the interest rate on the remaining principal to only 2%. He was reduced to a 2% mortgage and still couldn't even pay it. Even with these very generous modification terms, the plaintiffs still could not consistently make the required payments. There is no reason to conclude that a third modification would have a different outcome, or that better terms would have been available the third time. Moreover, the plaintiff's request is not timely, in that the foreclosure sale has already been held and Bank of New York and Ocwen have already incurred the time and expense of both enforcing the deed of trust and defending against this lawsuit. Plaintiff's delayed request for a third loan modification after defaulting on the first 2 fails to offer any meaningful legal opposition to the motion to dismiss. Accordingly, plaintiff's complaint should be dismissed with prejudice. And we're going to explain this word with prejudice for George so that he understands it. It's not that the judge has prejudice against you. It's not that the bank has prejudice against you in the term that you think they do. It means this has already been dealt with. He has no case to answer. He has no valid legal arguments to advance. And as such, dismiss this claim and stop him being allowed to bring a claim again based upon these facts. That is what with prejudice means, George. You cannot bring the claim again based upon the exact same facts. Respectfully submitted, Bank of New York. They've served it on George. So George will probably have got this today, if not yesterday. But I don't know if he's got access to PaySo. I very much doubt it, unless he's using it at the library. This, guys, is close to completion. If George is still in that house within the next 30 days, I'd be surprised. I'd be incredibly surprised. He has consistently failed at court to show the court exactly what he's trying to do. He files motions that are not really motions. It's just George bleating at the court and telling the court how mean the bank are, or how mean people are to him, and how he deserves this. He asks the court, this is what's so interesting, he asks the court to show him respect, and he asks for respect from the court, and he asks that the court do the right thing. Yet, a couple of weeks ago, George appeared on his show on Channel 95 Comcast and openly defamed and slandered the exact same judge he is asking for assistance and asking to do the right thing, and accused him of needing to go to Law School 101, that he is clearly not capable of doing his job, and asking who it is that is paying him. George has accused a sitting Virginia federal judge of taking bribes. What sort of a moron does that just because he's not getting his own way? And that's what all of this boils down to. George is throwing his toys out of the pram because he is not getting his own way. And when he doesn't get his own way, he attacks. And he attacks in the most ridiculous form, that he is unable to put forward any arguments that make any sense. He is unable to deal with the fact that the bank are correct here. You would not be in this position, George, if you paid your mortgage. Pay your mortgage, you don't get put in this position. If you couldn't afford the mortgage, sell the house. Sell the house and clear as much of the debt as you can. But you are too proud and too stupid to understand that this is not the way you do things. And you still, at this moment in time, believe you are going to be sat in that house come the end of the year. You will not be sat in that house. You need to be finding alternative accommodation, and you need to be thinking seriously about what you do, because you are not in the position you think you are. Your inability to look at your position and your inability to look at it objectively and see the point that perhaps you are not correct and that you are not able to advance any of the things that you think you can advance will be your downfall here, because you are too pig-headed to understand that you have lost, and you are too pig-headed to cut your losses now, prevent there being bigger problems with the bank, prevent the sheriff having to attend your property and drag you out of it because you refuse to accept that it's gone, and prevent you having the public embarrassment of that happening. Instead, you will sit in that house, not pay the mortgage, have another tenant living there who you have led to believe that he is safe having a home to live in when he doesn't, because he's going to be evicted as well by the sheriff. It's despicable. Your behaviour is despicable across the board. And I have tried to tell you this, and I even offered to help you and offered to give you some advice on this. You told me to go fuck myself and then threatened to murder me. So you now deserve everything you get, and this is karma. Your last show spoke about karma and reincarnation, and it's reincarnation, not recarnation. This is your karma for everything that you have done, all the wrongs you have done in your life. This is karma starting to come back at you. And I told you that I will be around every corner where you threaten someone. I will be around every court case that you file against any person. And I will not be silenced by you because you feel that you can bully people into not saying what a despicable human you are. And this guy's so deep-rooted now that George thinks that he can use the court as a tool to bully innocent people on the internet who have merely said, your show's crap and you're a bit of a homophobe and I don't agree with your views. Okay, some people have done some videos that take the piss out of some of the stuff you do, and they mock some of the show you have and the way you talk. That does not give you the right to start filing fruitless law cases everywhere, taking people to court. If you were in Sweden, you would not even be allowed in a court. They wouldn't even entertain any of this nonsense. But unfortunately, in America, they allow idiots to enter the court, and they allow idiots to file lawsuits against banks when they have no opposition, when they have no chance of success, and they allow it to file against people on the internet. You are despicable in the ultimate sense. Guys, I've got to stop because I know I'm starting to ramble because he's annoying me so much. By all means, ask questions in the comments. This video will be mirrored across several channels because George is rage flagging any channels and I am refusing to be silent. So this will be mirrored across several channels. You can email me, george@thegorgeousgeorge.show, and I'll try and get back to you if you've got questions. By all means, leave comments on any of the mirrors. I'll come and ask it here, there, and everywhere, and I'll do my best to answer your questions. Very exciting stuff coming up in the next 14 days, I would imagine, guys, and we should see some action going on. I am, of course, Marty McFly, your Swedish Attorney General and General Goon Squad. You are the resistance. Welcome to the Yarid War.